State of Minnesota versus Thomas Lane. District Court file number is 27 CR 2012951. Matter is on for sentencing. Council notes your appearances beginning with the state.
Good morning, Your Honor. It's Matthew Frank, Assistant Attorney General on behalf of the state.
Good morning, Your Honor. Earl Gray representing Thomas Lane and Amanda Montgomery behind me.
All right, and Mr. Lane is appearing remotely via WebEx. So, Mr. Frank, I'm going to turn to you first for any victim input.
Thank you, Your Honor. We did receive a victim impact statement on behalf of the family of George Floyd. Given the circumstances, they have asked just for us to read that. So if the court would permit, I would read that at this time.
You may.
All right, and again, this is written by the family on behalf of the family of George Floyd. Here we go again. I'm sure that's what many are thinking. But here's a reminder. My family and I never asked for this. No one wants to be a victim of a crime. It's truly unwanted and involuntary. How many more times will me and my family give a victim impact statement? As we are here today for the sentencing of former officer Thomas Lane, I just want to take a moment and try to recite the last unwanted and involuntary 2 years of me and my family's lives. First, there was a state trial, convicted, then sentencing and victim impact statement, then a federal guilty plea, then a sentencing, then a victim impact statement, then appeal, the conviction still waiting to hear back on the appeal on his sentence, then another guilty plea in state court and a conviction in federal court, sentenced in federal court, then victim impact statement, and now today yet another sentencing in state court and another victim impact statement. The other two demand a federal jury trial, found guilty and convicted, then months later the two are finally sentenced, then victim impact statement, but still awaiting for them to go to prison as of today. Then the other two refuse to plead guilty in state court and demand a jury trial for October 24th, 2022. Did I get that all right? I honestly don't know because it's been a lot. Talk about move on. Wow, really. Me and my family would love to move on, but there was just not much accountability. There wasn't a lot of space nor a place for me and my family to, quote, move on, close quote. We didn't deserve any of this, and it's all unwanted and involuntary. Some people may believe time heals all, and while I generally believe that saying, it's challenging to do so given these unfathomable set of circumstances. My family and I had to suffer through public grieving with the rest of the world who witnessed my uncle being brutally murdered with the assistance of former officer Thomas Lane. In the past 2 years, my family and I have just begun the process of grieving privately, which can be the worst. We want everyone here today to know we will never move on because there's no such thing, and as we all know, that's not how grieving works. The murder of George Perry Floyd will forever and continue to hurt always. We will never fully or really move on from the loss of a loved one. Acknowledging his death and referring to my uncle in the past tense will always send chills down my spine. We will always show up for George Floyd, but never move on. And again, that's from the family of George Floyd. Thank you, Your Honor.
All right. With regard to sentencing, Mr. Frank, any other comments from the state?
And I will just briefly, Your Honor, obviously, given the circumstances, I cannot and will not say much about the case itself today. We do have some technical matters that we have to address with the courts and deal with, and that's because our plea agreement with Mr. Lane includes a sentence shorter than the presumptive sentence, which means it is a durational departure. We would ask the court, and I believe the defense agrees with this, that this court, having sat through the entire trial of Derek Chauvin, could rely on the transcript of that trial to assess Mr. Lane's role in the offense and determine whether there is a sufficient basis for a short durational departure. As the court is aware, the presumptive sentence would be 41 to 57 months. Our plea agreement calls for a 36-month sentence. That's a 5-month durational departure. There is a basis, and we submit to the court to consider that basis, that Mr. Lane played a somewhat less culpable role in the commission of the offense. And more specifically, there were moments when Mr. Lane tried to change what was going on that day, initially trying to de-escalate the situation with Mr. Floyd and even calling attention to maybe some better way to handle it. Those are different than what the others at the scene did. While those may make his conduct less culpable, they of course do not relieve him of all responsibility, because they simply were inadequate to stop the excessive and unlawful subdual and restraint that ultimately led to Mr. Floyd's death. So we would ask the court to consider whether the record that you saw would justify a short 5-month durational departure on the basis that Mr. Lane's conduct was less serious than typical and the others involved. Your Honor, we're not asking for any restitution at this time. We would agree that this sentence would run concurrently with Mr. Lane's federal sentence that he is currently serving and in custody on. That's all I have, Your Honor. Thank you.
Mr. Gray, on behalf of Mr. Lane.
Your Honor, I just asked the court to follow the plea agreement and sentence Mr. Lane to 36 months. In our system, that would be 24 months of incarceration, and to sentence him concurrently with the federal sentence. That's all I have.
All right, Mr. Lane, is there anything you'd like to say before I impose sentence?
Your Honor.
All right, Mr. Lane, then as to count 2, your guilty plea is accepted, and based on that plea, you're found guilty of aiding and abetting manslaughter in the 2nd degree. Judgment of the court is that you are convicted of that offense. Count 1 is dismissed pursuant to the plea negotiation. You are sentenced to 36 months in prison with credit for 31 days already served. The PSI would failed to account for the 8 days he was in custody upon the initial charging. So the 31 days is correct. This is a mitigated durational departure. It is based on the plea agreement, your lesser role in the offense, and I base that on all of the video evidence that I watched during the State versus Chauvin trial, and your acceptance of responsibility. I'll just stop and note that I think it was a very wise decision for you to accept responsibility and move on with your life, even though the Floyd family has problems, and understandably so, problems moving on with their own lives, since we are still in process on 2 of the other defendants. And as they said, they might not ever be able to move on. This sentence will be concurrent with your federal sentence, and it will be served at a federal facility designated by the United States Bureau of Prisons. Provide a DNA sample as required by law, and register as a predatory offender if required by law. You are prohibited from possessing firearms and ammunition for the remainder of your life. Pay a $50 fine, $75 surcharge, and a $3 law library fee, all to be paid from prison wages. Any questions about the sentence?
Not from here, Your Honor.
No, Your Honor. Thank you.
All right, anything further from the state?
No, Your Honor.
For the defense?
No, Your Honor.
All right, thank you all. We're adjourned.
Thank you.